Well, here I am again. I'm Paul Brownstein, attorney here in Southampton, Lower Bucks County. And today I'd like to talk to you a little bit about some other things I do, because I do more than just family law, as I've said in some of my other conversations like this. I do wills for clients, and along with that, other related estate-type documents. For example, in a will, I very often get consulted by people who are family members. They want to make sure their children are provided for. They have money and property. They want to make sure it goes where they would like it to go. Sometimes there's grandchildren involved or others or charities. And so when they come to see me, we have a fairly involved conversation. I'm pretty thorough. Even on a first consultation for things like wills, I simply don't know how to do it in less than an hour. I'm very thorough. I get lots of information. And I ask questions of people who are here to be doing wills about things that they haven't thought about, which is very commonplace, but they have no reason to have thought about it, which is partly, I think, why you come here. Because, you don't have to see a lawyer to write a will. You can write it yourself in your own handwriting if it felt like it. That's legal. Doesn't mean it'll be right, but it's legal. Or people I do know go online and get forms online. And again, there's nothing wrong with those forms. They're perfectly proper. The problem is, A, which form should you use? And what goes in the blanks isn't always obvious. And unless you know what you're looking for in the many, many, many variations of how wills can be written, it can be very, very overwhelming. What do I know if I don't know what I'm supposed to ask in the first place? So I'm going to spend a moment or two here giving a typical pattern of things that who are going to do wills, a husband and wife, for example, with children, need to consider when they're doing a will. The first thing they want to think about is, who gets my property if I should die? Most often, the spouse wants to leave it to the other spouse, which is proper. In fact, when I have husbands and wives, we very often write what are called reciprocal wills. That means they're mirrors of each other. The husband's will and the wife's will are the same will, but the names are changed around for the same benefits for each. Because in Pennsylvania, husband and wife don't have just one will. They have their own. So you leave it to a spouse, assuming there is one. Very often, if you leave it to the spouse, you want to say what happens if your wife or husband should die before you or at the same time you do. Surprisingly enough to some people, that really happens. They don't think of that. Well, what happens if your spouse does die before you? Well, if there's children, usually they want to leave it to the children. Perfectly appropriate and a normal thing to do. If there's more than one child, most often, almost always, they leave it to the children in equal shares. I'm here to tell you that I have 3 children of my own. You love them all the same, but they're not the same. Each child of yours has their own separate needs. Something obvious, a large difference in age between 2 children. One is finished with school, out making a living, getting their way in the world. The other one may still be in school, high school or junior high school. Has a lot of years to go yet before that happens. Ordinarily, you ought to consider, do I want to leave more to the younger child, who may have more needs than the older child, should, when, and if the time come that I pass away. You need to consider those things. There's nothing inappropriate about that. While you cannot disinherit a spouse in Pennsylvania, they have a right to challenge the will and get their minimum share anyhow. You can disinherit anybody else you want to, or leave uneven shares to people if you want to. So you can leave 80% to one child and only 20% to the other, or leave it 50-50, or any ratio that makes sense to you. Something that has to be considered. Then comes another question. How old are your children? If they're under the age of 18, they're minors, and as such, you can't leave property directly to a minor. You must leave it to them in some kind of trust instrument. This is called a testamentary trust because it's part of your will, and wills is testamentary law. And so you want to leave it to some trusted person called a trustee, for obvious reasons, to handle the money for the child until they come of age. And the common kind of trust we write would be one in which they handle it for their health, education, welfare, and other benefits, and to an age that you think it would be suitable for the child to get the money in the child's own hands. I can tell you, when I was 18 or 19, what I would have done wouldn't have been very wise. I've gotten older, if not smarter. I know better now. Well, I get increasingly now people who write wills where the age of the trust coming into the hands of the child directly is going up. It used to be 18 pretty typically, or 21. Anymore, 23 or 25 or older is not at all unusual, and some people even much older, 35 or 40. Sometimes a child has a disability of some sort, or they're not responsible for money in some way. You can make a lifetime trust in that event, and there's lots of ways of doing that. The purpose of my little talk here is not to help you figure out how to be a lawyer, pass the exam, and write your own wills, but to put you in a mood to know better what there is to know. So I'm not giving those kind of details. Anyhow, kidding about it a bit, they say a magician should never tell us tricks. In any event, you would want to leave it in trust to the child if they're underage. Or perhaps, since nobody plans to die tomorrow, that minor child, or even the older child, may outlive you, but by the time you pass on, they may have children of their own. And maybe they might die the same time you in a common accident, for example. What's going to happen now? You might want the grandchild to have it instead of the child's share, or you might say, no, let the children take care of their own and let it go to the other children in larger shares. Either way, if there's going to be grandchildren, same issue. You need to have a trustee. Often it's the other partner of the child, mother or father as the case may be, but maybe you would rather trust somebody that's not married or related to your child. It could be a third party just as easily, as long as they're an adult and you have reason to have confidence in them. These are common things in wills. Well, what about the fact that you may or may not want to leave specific property to somebody? That sometimes matters. I have a couple of examples. I had a fellow who came in, he was a volunteer fireman. He left his toy fire truck collection to the guys in the firehouse. I had a fellow come in and he said, I want to leave nothing to my brothers. But I don't want to say that. I want to tell them how mad I am at them. Leave them a very small sum and say they only get it if they don't come to my funeral. True story. Or sometimes I get people who have no relatives at all. You can give it to friends. You can give it to charity. You can give it to a worthy cause. It will not go to the state of Pennsylvania if you don't leave a will and you don't have any relatives like mother, father, brother, sister, or children. The state law provides it will go to your relatives in order how closely related they are to you in order until there's no relatives. Then the state would get it. So if you have few relatives, you might want to provide what happens to the property you have if your few relatives do not survive you. You also want to consider what happens if you have young children and your wife or husband do not survive you. Maybe you want to name who the guardian would be. And the guardian for bringing up children doesn't have to be the same person who handles the money. Sometimes a loving relative may not be so good with money, and vice versa, and you can split the duties, or not as you wish. These are the kinds of things to provide for in a will. Maybe you want to provide for funeral directions for people that may not know what you want, and it matters to you. I recently had a fellow who wrote in his will to be buried with his softball equipment. He was a big softball player, loved it. He wanted his uniform, his glove, and all the rest of that in the coffin with him. I had a woman who had a cherished dog who had already died. In the will, it provided the dog's ashes in a box up inside the fireplace flue should be gotten and put in her coffin with her. People might not have known that, and so forth. Similarly, you may have other funeral directions. No viewing, a certain cemetery, not in the plot next to your ex-wife, and so forth. I smile a bit and tell things in a little funny way sometimes, even though I do very serious things. I like to think that sometimes a more human approach and a more normal approach is a better way of talking to people. I think people like that and appreciate it. It's bad enough having to have these stressful conversations about unpleasant topics anyway. My job is to get you where you need to be without at the same time getting you more stressed out than you have to be. People don't do wills. I think they think if I write a will, I'm going to die. Well, you are someday. It's good to have a will against that day because when the time comes and you really need a will and you haven't got one, it's too late.